All right, good morning, everyone. I'm Judge Jackie Pell, and we are in first appearance court this morning. Today, we're going to talk about probable cause, and then we'll talk about release conditions. Today is not your trial date, so today I would advise you not to speak on the record about your case because everything in this courtroom is being recorded. For those of you who are represented by the attorneys from the Public Defender's Office, I do have an attorney sitting in the courtroom with me, Attorney Michael Faberich, and then over at the main jail, those of you, you have an attorney over there. Also, you may want to speak to those attorneys before speaking on the record. If you have a private attorney, you can also let me know, and we will see how what can be accommodated if they're not present in the courtroom. The State Attorney's Office is represented by Mr. Eric Linder, and we have confinement status, pretrial supervision, and the clerk of courts in the courtroom, all needed to facilitate this morning the proceedings. So we're going to start at this time, and when I call your name, you'll come up to the podium, and then we'll address each person individually. Yes. What was the name? Last name is Richardson.
It's Marquise Richardson.
Okay.
He's approaching, Judge. He's here, man. Come on up, sir.
All right. Marquise Richardson, you are before the court this morning, sir, for aggravated battery with a deadly weapon, and count 2 is criminal mischief. The court does find probable cause, and I'll hear from the attorneys in regards to bond.
One moment, Judge. Your Honor, I'm going to be requesting a $10,000 bond on count 1, in order of no victim contact. Mr. Richardson was arrested for burglary of a conveyance with assault and domestic violence battery against the same alleged victim in 2016. Charges were dropped. He had a carrying concealed weapon in 2010.
Okay.
Judge, this is going to be a little bit too high for Mr. Richardson. The defense is going to be requesting a $5,000 bond on his behalf. After speaking with Mr. Richardson, he's been living in our community his whole entire life. He's 27 years old. He told me the good news is he just found a job. It's working at an irrigation company where he just started. Last week was a great week. He made approximately $600. Now, he does live separate and apart from the alleged victim. I did advise him that due to the domestic situation, the court's going to impose a no-contact order. He'll have no problem abiding by that court order. He lives in Lauderhill with his parents, and that's who he's going to be contacting to help post his monetary bond. From what he informed me, his father's a truck driver, so he believes if the court were to set a bond somewhere in the neighborhood of $5,000, that his father would be able to post his bond. So that's why the defense is requesting that amount, and we're going to be requesting a photo order so we can photograph the injuries that Mr. Richardson sustained.
All right, I will sign that photo order. I am going to impose a bond of $10,000 on count 1. No victim contact. Carolyn Kager.
Ms. Kager? Ms. Kager's here at main, Judge.
Ms. Kager, you're before the court today for 1 count of DUI, alcohol or drugs. The court does find probable cause.
Judge, we're going to be asking for the court to consider releasing Ms. Kager on pretrial release. She's 49 years old, been living here in Florida for almost 15 years now. She lives in Pembroke Pines with her sister, and from what she advised me, her sister's going through some financial tough times where she does not think that her sister will be able to afford to post her bond. So that's why we're asking for the court to consider releasing her pretrial release. And as far as employment, right now she's actively looking for work, Judge.
Okay.
One moment, Judge. Your Honor, state would be opposed to ROR to pretrial. As mentioned in the report, she had a previous DUI that she was convicted of in 2017 in Brevard County. And I would note that her breath results in that case were was .234.
Okay, in this case, I'm going to leave the bond at $1,000. Maria Beaton,
That's right, Your Honor. It's a medical reset. She's a medical reset.
okay, thank you.
You're welcome.
All right, Jacqueline Moss,
She's here present, Judge.
all right, Ms. Moss, you are before the court. Count 1 is possession of cocaine. Count 2 is felony violation of probation. That's a no bond hold. Count 3 is tampering with or fabricating physical evidence. The court does find probable cause. And I'll leave the bonds in place, 1,000 on count 1, 1,000 on count 3. And Ms. Moss will be before her division judge tomorrow at 8:30. Moctezuma Claudette,
She's approaching, Judge, here at me.
ma'am, you're before the court for count 1, carrying a concealed firearm, and count 2 is petty theft. The court does find probable cause.
Judge, at this time, nothing to add by the defense. I'm going to be contacting her family after court.
All right, your bond on count 1 is $1,000. Good luck. Keila Moreno,
North Broward, I believe.
okay, good morning. You are before the court. Count 1 is resisting officer without violence. Count 2, resisting officer without violence. Count 3, driving while license suspended. Count 4 is having an expired tag less than 6 months. 5 and 6 are felony capious matters. Those are both no bond holds. And count 7 is aggravated battery with a deadly weapon. As to your capious matters, you will be before your division judge tomorrow at 8:30. The court does find probable cause.
Judge, I did have an opportunity to speak to Mr. Moreno beforehand, before court this morning. He indicated that, I explained to him he had the no bond hold, so we're just asking the court keep the bond the same with regards to count 3.
Okay, and then as to count 7?
He's the
Mr. Moreno, hold on just a moment. Hold on just a moment.
Judge, I can tell the court that he indicated to me he's lived here all of his life, that he is single. He only has about $25 to his name. So I would ask the court to set a minimum bond, a minimal bond with regards to count 7. I don't even know if he'd be able to afford if the court set $1,000 bond, but that's what I would ask the court to set at this time.
Your Honor, the state would be requesting a $10,000 bond. The allegation is that Ms. Moreno struck the victim in his head with a tire iron.
well, which the victim supposed to have signed the waiver, and he's my fiance. We live together, actually.
Judge, I believe the victim's in the courtroom, actually. Sir, and Mr. Moreno, please don't talk about the facts of the case, okay?
Yes.
Thank you.
All right, good morning, sir. Okay, what's your name?
Clarence Coleman.
Last name is what?
Coleman.
Coleman.
Yes, ma'am.
All right, is there something you wish to speak to me about?
Yes, ma'am.
Okay, hold on, just say yes or no, something you wish to speak to me about. Okay, please raise your right hand. Do you swear or affirm to tell the truth? Okay, you can put your hand down. Please state your name again for the record.
Clarence Coleman.
Okay, and what is it that you wish to say without speaking about the case?
She's a very good person. She was to be there. And I signed a waiver, so I don't see
You signed a waiver when?
last year.
I'm sorry?
Last year.
You signed a waiver last year, but this incident occurred on April 22nd, 2019.
Yes, I'm talking about the assault.
He may be referring to count 7.
Okay,
And
July 11th, okay. State, are you aware of a waiver that has been signed in this case?
I have no waiver in the system here.
Okay.
Judge, I would, in light of the fact that the victim has signed a waiver with regards to count 7, I would ask the court to consider RORing him with regards to count 7 and just keeping the bond at $750.
What were your, well,
Please.
Mr. Coleman, are you in any way afraid of Mr. Moreno? You're,
Your Honor,
what about contact? These orders go with no contact orders. That means that you can't live in the same place, can't talk on the phone, can't email, can't do social media until further order of the court. Okay. Yes, Mr. Linder.
I have a concern. It appears my office is currently investigating a not in custody domestic violence allegation that Mr. Coleman claimed March 22nd of this year that Mr. Moreno or Ms. Moreno was on top of him, punching him in the face repeatedly. And he advised law enforcement he did not want to be touched by the defendant.
All right. As to count 7, I am going to impose a $5,000 bond, no victim contact until further order of the court. And as to the felony matters, I believe I said that before, you'll be in court tomorrow at 8:30.
Your Honor, please, if you could find it in your heart, listen, I don't have no priors, like, I'm not a bad person, and I can't afford $5,000. I can't.
All right,
Like,
I've already made a ruling, okay? Thank you for coming in. Alexandria Isaacs,
Is that still matter?
okay. Felix Lalange,
He's here present for Jermaine approaching.
good morning, sir. You're before the court. Count 1 is aggravated assault with a deadly weapon. Count 2 is touch or strike battery. The court does find probable cause.
Your Honor, I'm going to be requesting a $10,000 bond on count 1, a $2,500 bond on count 2, order no victim contact. I have concerns about the allegations that he threatened to kill at least one of the victims while in possession of a machete. I see at least 2 previous arrests, one in '09, one in '05, for domestic violence battery against different victims. Those were dropped, I know.
Okay,
Judge, as you heard, it's been many years since his prior contact with the criminal justice system regarding any similar related offenses. He's 47 years old, been living in our community now for about 15 years. He will find a separate place to live, separate and apart from the alleged victim. He is working. He works for a cosmetic auto body company where he's been employed there for the past 4 years, and we makes approximately $400 per week. And because of his financial situation, Judge, we're going to be requesting a $5,000 bond on count 1 and a $1,000 bond on count 2. So the defense would be asking for a total of $6,000 on Mr. Lelang's behalf, and we're going to ask for a phone order. I apologize, phone order, Judge.
all right, the court will sign a phone order. I'm going to impose a bond on count 1, $5,000, count 2, $2,000. No victim contact until further order of the court. Willie Ramirez. Thank you.
North Rock, Your Honor.
Mr. Ramirez, you're before the court this morning for one count of domestic battery by strangulation. The court does find probable cause.
I see no criminal history. That being said, based on the level of violence alleged, state would be requesting $10,000 bond, no victim contact.
He's lived here for 4 years. He is married. He has one child currently with the victim. He has 2 other children with someone else. He currently has a good job. He works for a Stryker, which is a medical company. The job is still available to him. What I would be asking is if the court would just consider setting a $1,000 bond in his case.
All right, court finds probable cause. I'm going to impose a bond of $5,000, no victim contact, until further order of the court. Franklin Guzman.
Is he approaching, Judge?
All right, Mr. Guzman, you're before the court. Count 1 is aggravated battery with a deadly weapon, and count 2 is aggravated assault with a deadly weapon. The court does find probable cause.
Your Honor, I'm going to be requesting bonds in the following amounts: $10,000 on 1, $7,500 on 2, no victim contact. I am concerned for the victim's safety in this case. I would note he has an arrest 2012 out of the state of Arizona for assault with intent to recklessly injure. It looks like he was pled out to disorderly conduct.
Okay.
Judge, we're going to be total of a $7,500 bond. We're requesting $5,000 on 1, $2,500 on 2. Mr. Guzman is employed. He works at Walmart. He's been employed there with Walmart for about 20 years, making approximately $20 per hour. As you heard, the last time he had any sort of contact was 7 years ago on a misdemeanor offense. Judge, he's going to live separate and apart. He's going to be residing with his son. Lives in Davie, and from what he informed me, that's the person that's going to help post his monetary bond. His son works at a warehouse. So he does have limited financial resources. And that is why we're requesting a 5,000 on one and 2,500 on two.
All right, the court does find probable cause. The allegations here are that Mr. Guzman drove his vehicle towards the alleged victims, knocking one off a chair and almost striking the other one. The court does find that reasonable bond on this, under these circumstances, count one, $10,000, count two, $7,500. No victim contact until further order of the court. All right, Mr. Shade, we have a few cases we can. Good morning. On page 11, John Seymour.
Mr. Seymour, come on up, please. John Seymour? John Seymour? Is he here? John Seymour on page 11? He should be here, right? Or did he step out of the restroom? We're trying to locate him right now, John.
All right. And how about Vernon Keat? Is he in the, today? He's on page 14.
He's still a medical research.
He's still a medical reset. All right. And how about Gongalo Vincent on page 23,
Oh, no.
North Broward.
North Broward?
Good morning.
All right. Mr. Vincent is before the court for one count of battery on a person 65 years of age or older. Count two and counts 2, 3, and 4 are battery on an officer. Count 5, criminal mischief, and 6 and 7 are misdemeanor capious matters, both of which has bonds of $100 attached to them. The court does find probable cause. And I'll hear from the parties first.
Judge, as for the MOs, we just asked that it be sent to the division.
Okay,
Your Honor, I'm going to be requesting $10,000 bond on count one, 2,500 each on two through 4. This is based on the age of the alleged victim. Bless you. Also noting, he's had thefts in the past, but most notably, 2013, he was convicted after a violation of probation of aggravated battery with a deadly weapon. And obviously, I'd be requesting no victim contact.
He has lived in the area for 18 years. He does get an SSI check for $750. The report indicated that there are some issues as well. I don't believe he would be able to afford that amount of bond at this time. I would ask for the court to set a minimal bond with regards to these things. And I apologize because I did read the report quickly. I don't believe he actually physically attacked anybody. I think it was he pushed a door open hard, and it caused the mother to fall down. And I believe that it was that allegation, I think, that caused it. So I just asked the court to take that into consideration as well when setting the bond.
and also in reviewing in the probable cause affidavit, I know that somebody mentioned that there may be some mental health issues as well.
Correct, Judge.
So I'm gonna impose $2,500 on counts 1 through 4.
This guy was arrested March 27th. We got out.
but also means no victim contact, and,
So, okay, got it.
and then he'll, be before his division judges on the other matter.
And Judge, if you could just make sure he understands what no victim contact is.
Mr. Vincent?
Yeah.
When I say no victim contact, it means that you cannot call, you cannot go to the house, you cannot be on social media, you cannot text, you cannot ask a third person to get in touch with your mother and
Excuse me, what do you
Okay.
mean by third person? You mean
no,
Mine?
right. You can't ask somebody else to call them for you or to reach out to her for you on your behalf. Do you
So
understand?
how am I gonna get my stuff?
Well, do you understand what I'm saying? No
I
contact?
understand, but I wanna say, I wanna go by what's right. How am
No,
I gonna get my stuff? I have my documents, I have my clothing.
sir.
Yeah.
If you have a problem with understanding no contact, I can make changes. Okay?
Yeah,
So
but I'm
so
asking you, how am I gonna get my
no,
stuff?
you're not gonna get them. Okay?
So, naked in the street?
I'm sorry?
Walking naked in the street?
You can speak with your attorney further. I'm not going to have any more conversation with you about this.
Judge, what I would ask is just one thing, if he would be allowed to contact law enforcement, should he be able to bond out and return to the house one time with law enforcement in order to get his items?
One time with law enforcement. Only with
Okay.
a
That's
police
what I was
officer.
asking for, that's fine, that's
Okay.
fine.
Great, thank you very much, Judge.
All right, is John Seymour back?
Seymour?
He's on his way, Judge.
All right,
Those red pants?
Salmon, salmon, no.
Just checking, just wondering.
Salmon, Mr. Shade. It was Easter yesterday.
it's Easter.
They look good, they look good.
Always looking good, Mr. Shade.
All right, while we're waiting for Mr. Seymour, is Hernan Navas available?
Judge, he's gonna be a medical reset.
Okay. How about Quentin Humphrey?
He is here present. Mr. Humphrey, come on up, please. He's approaching, Judge.
All right, Mr. Humphrey, you're before the court this morning for count 1 is aggravated assault with a deadly weapon without intent to kill. Count 2 is domestic battery by strangulation. Count 3 is kidnap, inflicting bodily harm or terrorize other. Counts 4 and 5 are domestic battery by strangulation, and count 6 is false imprisonment. The court does find probable cause as to all 6 counts. And I will hear from the parties as to bond.
Your Honor, the state is going to be seeking a no bond hold on count 3 upon a finding of proof evident or presumption great for first appearance purposes. I would argue that the totality of the evidence contained in the probable cause affidavit would rise to that level, and I do believe a no bond hold is necessary at this point in time to ensure the safety of the victim.
Okay?
Mr. Faber, we can't hear you.
Judge, we would just ask the court that holding somebody no bond requires proof evident presumption great, which is one of the highest burdens in the criminal justice system. Because of that, Judge, we don't have anybody here to give live testimony, and while I know that the court can use a probable cause affidavit, that certainly you can't, from a probable cause affidavit, take into other things into account, like, you know, what the officers or the victims would be testifying, whether or not they're believable within their testimony in that. So based on that, Judge, we would ask that the court not find proof evident presumption great. If the court's inclined to find proof evident presumption great, I would ask the court to use its discretion in setting a bond.
Okay. So we're only, at this point, I imagine everyone is only dealing with count 3. So As to count 3, the court does find probable cause, and I am making a further preliminary finding of proof evident presumption great. This probable cause affidavit is very detailed, and further, the alleged victim in this case does wish to prosecute. So I'm going to make a preliminary finding of proof evident presumption great. That is without prejudice for the defendant to have a bond hearing based on State v. Author in his division. All right, so as to the other counts,
Your Honor, based on the level of violence on all the other counts, I'm going to be requesting bond in the amount of $15,000 per count, obviously in order of no victim contact.
okay. All right, Mr. Romero?
Judge, considering that the court found proof evident presumption great and is holding Mr. Humphrey no bond on count 3, he's going to have to go in front of his division judge to seek some sort of relief through an Arthur hearing. So at this time, we're going to be deferring any sort of bond arguments for that time, Judge.
Okay. All right, so as to counts 1, 2, 4, 5, and 6, I'm going to impose a bond of $10,000 on each count. No victim contact until further order of the court.
And Judge, Mr. Seymour is here.
Okay.
Mr. Seymour, come on up, please. He's approaching, Judge. Come on up, sir. Be careful.
How much is the property worth? How much is the property worth? I don't wanna know.
Wait, Judge, you need to hold on to the podium.
All right, Mr. Seymour.
Yes, ma'am.
Mr. Seymour, you have 2 misdemeanor capious matters for possession of drug paraphernalia. One is from July of last year, 2018, and then the other one is November 5 of 2018. You did not show up for court on those dates.
Ma'am, they had, stopped me on 6th Street, and I told them I live in the street, and I didn't have no address, but the last place I stayed was in the Oakland Park, but now I stay on 15, and I showed the police officer where I stayed, and he wrote down the address.
Okay. Well, what do you want to do today, Mr. Seymour?
Ma'am,
What do you want to do today with these cases? Do you want to resolve these cases today?
yes, ma'am.
All right, Mr. Seymour. Your sentence will be adjudication and time served if you want to resolve your cases. Is that what you wish to do?
Yes, ma'am.
All right. As best as you can, raise your right hand. The other one. The other one. Do you swear or affirm to tell the truth?
I'm bad here.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Seymour, do you understand what I'm saying to you today?
Yes, ma'am.
And do you understand that you are going to resolve these 2 cases that are pending from last year today? Do you understand that?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
Right now, no, ma'am.
Okay, yes. I'm only concerned about right now. Have you ever been treated for mental or emotional illness?
I was say that boy. I About with a what?
Mental or emotional illness?
Have I been sentenced for that?
No. Have you ever been treated for that?
Yeah.
Are you taking any medications today?
No, ma'am.
All right. And so, Mr. Seymour, what plea do you wish to enter today? Guilty or no contest?
I would say no content.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck. I'm sorry? Court costs is applied to the cases, yes. We'll get 6 months to pay his court costs. All right, the Spanish interpreter is in the building. Who needs a Spanish interpreter?
Judge, they called me from the main jail. They said starting on page 10. That was all I got.
It's like everybody on page 10?
No, two people on page 10 would be Mr. Ariana and Mr. Villatoro. Also, a gentleman on page 12, which would be Mr. Escobar. And the final gentleman would be Mr. Gonzalez on page 16. So 4 individuals at this time.
All right, good morning. Good morning. Is there a firm to translate from Spanish to English and English to Spanish?
I do, Gabriel Sinisi, co-interpreter.
All right, Mr. Sinisi, good morning.
Good morning.
Ronaldo Oriano Ovando? Is that who we have before us?
Ese es el que tenemos ante nosotros.
All right, sir, you are before the court. Count 1 is possession of cannabis, 20 grams or less.
Señor, está ante el tribunal hoy. El primer cargo es posesión de cannabis, 20 gramos o menos.
Count 2 is driving while license suspended without knowledge, not for magistrate.
El segundo cargo no es para magistratura y es conducir con licencia suspendida sin conocimiento.
Count 3, driving without lights, not for magistrate.
Y tampoco es para la magistratura de hoy conducir sin luces.
Count 4 is a traffic KPS matter.
El cuarto cargo es un caso de tráfico.
Driving while license suspended is a charge.
El cargo es conducir con licencia suspendida y es una orden de arresto.
And that KPS was issued January 24th of this year.
Y esa orden de arresto fue emitida el 24 de enero de este año.
The court does find probable cause,
El tribunal dictamina que sí existe motivo fundado
and I will hear from the parties in regards to bond.
y abriré la sala para las partes.
Judge, we're going to be requesting a phone order.
Señora
Okay?
jueza, vamos a estar pidiendo una orden judicial para acceso al teléfono.
All right, I will sign that phone order.
Firmaré esa orden judicial para el teléfono.
The bond on count 1 is $100,
La fianza, el primer cargo es 100
and the KPS has a bond of $500.
y la orden de arresto tiene una fianza de $500.
All right, good luck, sir.
Suerte, señor.
Jose Villatoro, Toro.
Señor Villatoro. Villatoro.
Sir, you're before the court for one count of DUI.
Señor, se encuentra hoy ante el tribunal por un cargo de manejar bajo la influencia.
Count 2 is license not carried.
El segundo cargo es no portar la licencia a conducir.
That's not for magistrate.
No es para la audiencia de hoy.
And count 3 is driving in the wrong lane, not for magistrate.
Y el tercer cargo es conducir del lado equivocado del camino y tampoco es para magistratura.
The court does find probable cause.
Sí dictamina el tribunal que existe motivo fundado.
Judge, we're going to be requesting a property order so that Mr. Villatoro can self-file.
Okay,
Señora jueza, vamos a estar requiriendo una orden judicial para acceso a la propiedad para que pueda tener acceso el señor Villatoro.
all right, so I will sign that order. The bond on count 1 is $1,000.
Firmaré esa orden y la fianza para el primer cargo es $1,000.
Brian Escobar.
He's approaching, Judge.
Okay. Mr. Escobar, you're before the court today.
Señor Escobar se encuentra hoy ante el tribunal.
Count one is operating without a valid driver's license.
El primer cargo es conducir sin licencia válida.
Counts 2 and 3 is leaving the scene of a crash.
Y los cargos segundo y tercero es abandonar el sitio de un accidente.
The court does find probable cause.
Sí dictamina el tribunal que existe motivo fundado.
Judge, at this time, nothing to add by the defense. He gave me the phone number of his family. I'm gonna be contacting his family so they can post his monetary bond.
Okay.
Señora jueza, el señor Escobar va a estar contactando a la familia para que ellos puedan pagar la fianza monetaria. Ok. Yo.
Did the state wish to be heard?
No, Judge.
¿Desea ser acusado a la fiscalía? No, no hace falta, señor.
He's a total bond of $100.
Una fianza total de $100.
Lo voy a llamar a tu hermano después. Apenas pague, doctor.
Brennan Gonzalez.
Señor González.
All right, Mr. Gonzalez, you're before the court today.
Señor González se encuentra ante el tribunal hoy.
Count one is disorderly intoxication.
El primer cargo es intoxicación pública.
Count two, resisting officer without
El
violence.
segundo cargo, resistir a un oficial sin violencia.
Count three is trespassing.
El tercer cargo es entrado de permanencia ilícita.
And count four is corrupt by threatening a public servant.
Y el cuarto es corrupción por medio de amenaza a un oficial público.
The court does find probable cause.
El tribunal dictamina que sí existe motivo fundado.
I'll hear from anyone who wants to be heard.
Cualquiera de las partes que quisiera escuchar.
Judge, I'm going to be asking the court to consider an ROR. Mr. Gonzalez was born here.
Su señoría, voy a estar pidiendo si puede considerar el tribunal libertad bajo la palabra. El señor González nació aquí,
He's 24 years old.
tiene 24 años,
He works at Texas de Brazil.
trabaja en Texas de Brasil,
He's been there employed for 6 months, and he lives locally here in Sunrise.
ha estado trabajando 16 meses y trabaja aquí, vive aquí en Sunrise.
My understanding, this is his first contact with the criminal justice system.
Entiendo que este es su primer contacto con el sistema jurídico.
Now, he does speak English, but he feels more comfortable in Spanish. He wanted to understand everything. That's why we're using a Spanish interpreter.
Ahora él sí habla inglés, pero él quería entender todo y él se sentía más cómodo comunicándose en español.
Now, he did give me the phone number of his family, who, if the court's not inclined to straight ROR, I'd ask the court to set $1,000 bond, and I will be contacting his family after court.
Sí me dio el número de teléfono de su familia y si no estaría dispuesto a considerar la libertad bajo palabra, yo contactaría a la familia del señor y pagar una fianza si consideraría de $1,000.
Your Honor, the state would be requesting a $5,000 bond on count 4.
Su señoría, la fiscalía estaría peticionando una fianza de $5,000 para el cuarto cargo.
Based on the threat he made to the arresting officers to kill them and their families.
Basada en la amenaza que él hizo de matar a los oficiales y a sus familias.
I'm looking at the booking report that says that Mr. Gonzalez was born in Argentina.
Estoy viendo la hoja de fichaje y dice que el señor González nació en Argentina.
So was he born here or was he born in Argentina?
Así que nació aquí o nació en Argentina.
Because that's it was just said that he was born in here.
Porque recién se mencionó que él había nacido aquí.
4 años me fui a vivir a Argentina,
Judge,
por
he
20
was-
años allá.
Judge, he was born here, and he went to Argentina when he was 4 years old. He has his social security, and from what he tells me, his birth certificate from here.
Y mi
Eh,
pasa-
Su señoría, él nació aquí y viajó a la Argentina a la edad de 4 años. Él tiene número de seguridad social y tiene pasaporte.
All right, as to count 4, I'm gonna impose a bond of $5,000.
Con respecto al cuarto cargo, voy a imponer una fianza de $5,000.
All right, good luck, sir.
Suerte, señor.
Does anyone else need a Spanish interpreter?
No one else here at Maine, Judge.
North Broward, Paul Ryan, Conti. Hearing nothing, Mr. Sinisi, thank you.
Thank you, Your Honor. Have a good day.
You too. All right, let's continue. Brian Spatafora.
Please approach and just come on up, sir.
All right, sir, you're before the court for count 1 is aggravated battery on a person 65 or older. Count 2 is burglary with assault or battery. Count 3 is violation of injunction, domestic violence protection order. And 4 is a felony capious matter. There is a no bond hold attached to that and is not for magistrate. The court does find probable cause.
Good morning, Your Honor. Nancy Hunnigan, Pretrial Services. He's currently out on pretrial for case number 18013786. CF10A. We're requesting his pretrial is revoked. The case is for grand theft in the 3rd degree. He was released out on pretrial November 7th of 2018.
Okay.
Your Hon- He's already been held by bond. He didn't trip the court. Your Honor, the state would be seeking a no bond hold on count 2. Upon a finding of proof evident or presumption great for first appearance purposes. Still relying upon the probable cause affidavit, noting that Mr. Spatafora was the place of arrest is the incident location. I would also note the victim, his mother, provided a sworn statement. And the allegations would satisfy the elements of the offense. I'll leave that for now.
Oh, okay. Okay.
Your Honor, just for the record, I'd also note the physical evidence mentioned in the report that the red imprint of his fingers on the victim's right arm that were left when he grabbed her.
Judge, having had a chance to read the probable cause affidavit, I would just argue that proof evident presumption grade, again, is one of the highest burdens to detain somebody. We're without the privilege of having either the victim or an officer here for live testimony so that the court could weigh their dispositions and their truthfulness with regards to something that's just on black and white paper. Based on that, Judge, I would ask that the court not find proof evident presumption great, but if the court's inclined to do that, I would ask the court to use its discretion in setting a bond.
For making a preliminary finding of proof evident presumption great, the law does not require that we bring the live testimony in the courtroom. The law does give the court discretion to make that finding based on the probable cause affidavit that is presented to the court, first appearance court. In this matter, we have an injunction in place, a domestic violence injunction in place, and where the defendant is not to be at this location, and this is at the same location where there's an injunction, is where he is arrested. So as to count 2, the court will make a preliminary finding of proof evident presumption great, and Mr. Spatafora will be held no bond as to that count. And and I'll hear from the parties if anyone wants to further address the bonds on the other counts.
Your Honor, I'm going to be seeking a $15,000 bond on count 1, a $10,000 bond on count 3. Mr. Spatafora was arrested last year for domestic violence battery due to felony battery due to priors, and 2 counts of violating a domestic violence injunction that was against the same alleged victim that was dropped. 2014, he was convicted of 2 counts of violating a domestic violence injunction. He violated probation in that case. 1998, shooting at or throwing a deadly missile. 87, attempted burglary of a dwelling. But he has shown in the past that he will willfully ignore court orders to stay away from protected parties.
So the amount of bond that you are seeking?
15 and 10 on 1 and 3.
All right, and then to further make the record clear as to count 2, the finding of proof evident presumption great, it is without prejudice for the defendant to have a bond hearing in his division based on State v. Author. So as to the case on which Mr. Spatafora is on pre-trial supervision, case number 18-013786-CF10A, the court will revoke the pretrial supervision, and Mr. Spatafora will be held no bond on that case as well. And as to counts 1 and 2 on the new arrest, the court will impose $10,000 on each count. All right, good luck. So
Your Honor,
no
was that on
victim
1 and 3?
contact. What was that?
Was that on 1 and 3?
1 and 3. Sorry. Thank you. Okay. Jarrell Edwards.
Mr. Edwards?
Yes.
It's here, President Judge, I mean.
All right, Mr. Edwards, you're before the court today for possession of cannabis charge. The court does find probable cause.
Judge, it's me, Mr. Edwards. He wishes to see if the state has a plea offer on this misdemeanor cannabis form.
Okay.
Offers to withhold court costs.
He wishes to accept the state's offer, Judge.
All right, Mr. Edwards, as best you can, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. Mr. Edwards, you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Do you need any more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
No.
And you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes.
Yes.
What plea do you wish to enter, Mr. Edwards?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentence serves withhold adjudication and court costs. Good luck. All right, last name NGO,
He's here, Judge. We requested a Vietnamese interpreter.
Judge,
okay?
I did call for a Vietnamese interpreter. They indicated it's probably nothing they can get this morning, but I would ask that it be reset for the afternoon.
All right,
They may
that's,
be able to get one by then.
all right, that's fine. We'll reset for the afternoon.
I think you did.
All right, Hamza Jafar,
Mr. Jafar is here present, Judge.
Mr. Jafar, you're before the court for count one is loitering and prowling, count two is possession of cannabis 20 grams or less.
Yes, Judge. And speaking, Mr. Jafar, he wishes to resolve this case. We wanted to see if the state has a plea offer on this case.
All right,
Yeah. One moment, Your Honor. See there? The offer would be a withhold court cost on both counts.
He wishes to accept the state's offer, Judge.
all right, Mr. Jafar, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, sir, you can put your hand down. Do you understand everything that's going on here today, sir?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No one.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Have you ever been treated for mental or emotional illness?
Never.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
I am a U.S. citizen. I've been here my whole life.
All right, what plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given, and your sentence serves a withhold adjudication and court costs. Good luck. Robert Hernandez.
Mr. Hernandez, come on up, please. He's approaching, Judge. You're at me.
Mr. Hernandez has a misdemeanor capias for a petty theft charge.
Correct, Judge.
From the capias was issued December 12th of 2018.
Jen, speaking, Mr. Hernandez, he wishes to resolve this matter today.
The offer that's documented by the state is a withhold court cost, no return to the Publix at 1740 Polk Street in Hollywood.
Okay.
Judge, Mr. Hernandez wishes to accept the state's offer.
All right, Mr. Hernandez, as best you can, raise your right hand, please. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir. Do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Have you ever been treated for a mental or emotional illness?
No.
Sir, you understand you have a right to go to trial, but by taking a plea today, you're giving up that right?
Yes.
And do you understand, sir, that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Hernandez?
No contest.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence serves a withhold adjudication and court costs, and sir, no return to Publix in Hollywood on Polk Street. You understand that? Okay. Jason Edwards.
Judge, I've been advised confinement status is resetting it for PM.
Okay. Jason Edwards is being reset for PM. Dean Seeley.
Dean, see, no, please.
Okay, so do we have Mr. Edwards? Is Mr. Edwards in the room?
Mr. Seeley, right? Oh, wait. Mr. Seeley,
I know Mr.
Mr.
Seeley.
Edwards is not here in the room. The deputies are informing me that confinement status contacted them to tell them that he's being reset for this afternoon.
Okay, so we'll have Mr. Edwards this afternoon. What is the status with Mr. Seeley?
He's here present, Judge.
Did you want? All right, confinement is asking me to reset Mr. Seeley as well for the afternoon.
Yes, Judge.
All right. All right, Derek Gilholly.
He's here present, Judge.
Mr. Gilholly, you're before the court, count 1 for possession of cannabis 20 grams or less, and count 2 is operating without a valid driver's license. The court does find probable cause.
Judge, and speaking to Mr. Gilholly, my understanding is this is his first adult arrest. Considering these are nonviolent misdemeanor cannabis, I'm going to ask the court to consider an ROR on Mr. Gilholly's behalf.
All right, Mr. Gilholly will be ROR'd on count 1. Jose Cortez. Okay.
Mr. Cortez is approaching, Judge. Come on up, sir.
Mr. Cortez, good morning. You're before the court for count 1 is DUI, count 2 is possession of open container, and count 3 is driving on the wrong side of 2 and 3 are not for magistrate. As to count 1, I've been advised, the court does find probable cause, and I've been advised that your bond has been posted. Good luck, sir. Luke Harris.
Mr. Harris, come on up, please.
Mr. Harris, you're before the court for a misdemeanor capious matter. You failed to show for your arraignment on April 10th. And the charges for petty theft. The court does find probable cause. What does Mr. Harris wish to do?
Judge, and speaking Mr. Harris, he wishes to resolve this matter today.
1 moment, Judge.
Okay.
The documented offers withhold court costs.
All right.
He wishes to accept the state's offer, Judge.
All right, Mr. Harris, please raise your right hand. To swear affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Harris, you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you do have the right to go to trial, but by taking a plea today, you're giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Harris?
No contest.
All right, sir, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence serves a withhold adjudication and court costs. Good luck. Anthony Anderson.
He's approaching, Judge. Come on up, Mr. Anderson.
Good morning, Your Honor.
Good morning, Mr. Anderson. You are before the court for a traffic capious matter. And it looks like you didn't show up for your arraignment. So the court does find probable cause. What does Mr. Anderson wish to do?
Judge, in speaking to Mr. Anderson earlier today, he wishes to resolve this matter.
Offers a time served.
All right, if Mr. Anderson wishes to resolve his case, the sentence will be adjudication and time served.
He wishes to accept it.
All right, Mr. Anderson, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Do you understand everything that's going on here today?
Correct. Yes, ma'am.
Are you under the influence of drugs or alcohol?
Not at all.
Is anyone forcing you to resolve your case?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am. Not at all.
And you understand you have the right to go to trial, but by taking a plea today, you are giving up that right.
Correct.
Have you
Yes.
have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that taking a plea today could subject you to deportation or immigration changes?
Correct. Yes, I do.
All right, what plea do you wish to enter, Mr. Anderson?
No contact.
All right, I accept your no contest plea, find that it's freely and voluntarily given. Your sentence serves adjudication and time served. Good luck. Lawrence Fisher.
Mr. Fisher, come on up, please. He's approaching, Judge.
All right, Mr. Fisher is before the court for misdemeanor violation of pretrial. That's not for magistrate. He has a $100 bond. Counts 2 and 3 are misdemeanor capious matters. And he has a bond of $500 on count 2 and $250 on count 3. So the court finds probable cause. He is scheduled to be in court tomorrow at 9:30.
Judge, that is correct. I did advise him that he has a court date tomorrow, but he wishes me to ask the court if the court would consider resolving these matters today.
State has no offer at this time.
The charges of petty theft with the prior conviction, 2 petty thefts. So with that, we will leave it for him to resolve in his division. Ismail Rivas.
No brow, Your Honor.
All right, Mr. Rivas, you're before the court. Count 1 is petty theft, and count 2 is dealing in stolen property. The court does find probable cause. Does anyone wish to be heard?
Judge, I can tell the court that he's lived here for approximately 2 years. He indicated that he's single, has no children. He does have a job where he works in that. He has no money at this time, though, and that's going to be his issue. I would ask the court if the court would consider either RORing him or releasing him to pretrial release. If the court's not inclined to do that, I would ask that the bond on count 2 be lowered to $1,000 because he indicated he has no money at all.
Your Honor, that's that the bond be left in place. Mr. Rivas is out right now on a pending felony criminal mischief before Judge McCarthy. He was arrested. He failed to appear at his arraignment and was held no bond. Judge McCarthy ROR'd him on February 28th. He then got picked up and pled out to a petty theft April 1st of this year.
What was the sentence on April 1st?
Adjudication time served.
All right, I will leave the bond in place at $3,500. Good luck, sir. Frederick Harden.
Harden, come on up. He's approaching, Judge.
Mr. Harden, you're before the court. Count 1 is possession of cocaine. Counts 2 and 3 are felony capious matters which are not for magistrate with no bond holds. The bond on count, the court does find probable cause. The bond on count one is $1,000, and you'll be before your division judge tomorrow at 8:30. Carlos Padilla,
Mr. Padilla, come on up, please.
Mr. Padilla, you're before the court. Count one is refusing to submit to a DUI test, and count three is driving on a permanently revoked driver's license. The court does find probable cause.
Judge, we're gonna be requesting a photo order.
Okay. All right, I'll sign the photo order. All right, the bond is $1,000 on count two. Curtis White.
No problem.
Mr. White, you're before the court. Count one is driving while license suspended, and count two is a felony violation of probation. That is a no bond hold, and you will be going before your felony judge tomorrow at 8:30. The court does find probable cause, and the bond on count one is $100. Good luck, sir. Daryl Mitchell.
Approaching judge.
All right, Mr. Mitchell, you're before the court. Count one is possession of MDMA. Count two is possession of drug paraphernalia. Count three, operating without a valid driver's license. Count four, operating a motorcycle without license. And count five, failure to register the motor. The court does find probable cause, and will hear as to bond.
Judge, unfortunately, speaking Mr. Mitchell, no one's going to be able to afford to post his monetary bond. From what he advises me right now, he's in the process of applying for disability. He's been living in our community, from what he informs me, since 1976. He's 54 years old. He lives with his brother in Pompano Beach. From what he advised me, his brother is on a fixed income getting Social Security, so he's not in a financial position to post his monetary bond. Mr. Mitchell did advise me, though, he does have contact with the criminal justice system, but the last time was, from what he thinks, is probably over 7 years ago. So we're going to be asking on this nonviolent offense to consider releasing Mr. Mitchell on pretrial release.
Well, he got out of prison 4 years ago. Well, a little less than 4 years ago. That was on a grand theft that he was sentenced as a habitual offender. In 2011, he was sentenced, well, he had a 2011 arson of an occupied structure that he was sentenced to 3 years state prison as a habitual offender. In the mid-'80s, he went to prison on 3 separate robberies with firearms or deadly weapons, 2 separate aggravated assaults. Your Honor, based on his, one moment, he's been to state prison in the state of Georgia. Your Honor, based on the fact that he's been to prison in 2 separate states, qualified as a habitual offender in the state of Florida, and a previous arson, the state would oppose pretrial.
As to count one, Mr. Mitchell's bond is $1,000. Darius Gutierrez.
He's approaching Judge Chapman.
All right, sir, you're before the court. Count one is possession of THC. Count two is possession of cannabis, 20 grams or less. Count three, resisting officer without violence. And count four is loitering or prowling. The court does find probable cause.
Judge, we're going to be requesting ROR on Mr. Gutierrez's behalf. He's 19 years old. He just got employed at a company called Wall to Wall Painting. He's been there about 2 weeks. He doesn't want to lose that job. He lives with his mom, but from what Mr. Gutierrez advised me, there's no one going to be able to post his bond. Considering this is possession of THC, that's why we're requesting the court to consider releasing him on ROI.
One moment, Judge. No. He was just arrested less than 10 days ago. Your Honor, state would oppose pretrial. Mr. Gutierrez, from what I can tell, was arrested on April 14th in Palm Beach County for fleeing and eluding law enforcement. That's pending right now. He's out on a $5,000 bond.
All right. So the bond, as to this new arrest, is $1,000. Abdul Mustafa.
He's here, I mean.
All right, Mr. Mustafa, you're before the court. Count one is a misdemeanor capias. And then count two is an out-of-county hold, which is no bond and not from magistrate. The bond on count one is $500. The court does find probable cause.
Judge, considering count two is a felony offense, I believe, from the Dade County, would the court consider an RO on count one so Dade County can pick him up on count two on the felony offense?
One moment. I just,
Capias is an old capias.
and I just wish there was some way we could get him in front of a judge. It's not like he's gonna go to Dade County tomorrow morning. And I just wish there was a way we can get him in front of a judge in Broward, because the capias was issued by a Broward judge, and it's, it's going on almost 5 years now, this case.
All right. Well, it would have to, it's a satellite, judge, so it'd have to be transferred up here and, have to be transferred to Maine. It is a 2014 KPS, and the charge in Palm Beach is a robbery strong arm. I'm gonna ROR him on the Broward KPS. All right, Giovanni Cabreja.
And Judge, unfortunately, this was our cutoff, so I'm gonna need time to speak with Mr. Cabreja. So the court were inclined to speak to the other gentleman in the other facilities.
All right.
Thank you.
All right, is there anyone at North Broward that we're waiting to address?
Christopher Eubanks.
Eubanks.
All right. So Christopher Eubank. All right, Mr. Eubank is before the court for one count of aggravated battery with a deadly weapon. The court does find probable cause.
Judge, I can tell the court that he's lived here for 40 years, that he is single. He has 2 grown children. He's not currently working because he's retired. He used to be a crane operator and a truck driver. He indicated that there's nobody to help him post his bond at this point. Based on that, he wouldn't be able to afford any bond. What I would be asking is the court to consider RORing him. If the court's not inclined to do that, I would ask the court to consider releasing him to pretrial release.
Your Honor, the state would oppose. I am concerned, concerned for the safety of the community. It does not appear that Mr. Eubank has a residence. In this matter, he sliced the victim in his arm and stomach with a box cutter, requiring a total of 15 staples. He has a lengthy criminal history. I'm showing, as far as the state of Florida, at least a total of 50 previous arrests, both misdemeanor and felonies. At this point in time, I don't have, on about 42, there are no disposition listed. I'm showing, yes. I know he has a history out of the state of Wisconsin. And a history that goes way back into the 70s out of the state of Maryland. I would be requesting a $15,000 bond, no victim contact.
All right, the court does find probable cause. I'm imposing a $15,000 bond, no victim contact. All right, sir, good luck. Is there anyone else at North Broward?
No, ma'am, that's the last one.
All right. Do we have, thank you. Is there anyone at Conti?
No, ma'am, we're good.
Thank you.
Yes, ma'am.
And Paul Ryan? Do we have anyone at Paul Ryan? Hearing nothing. All right. All right, Mr. Romero, when you're ready, the court's gonna take a brief recess unless you're ready. All right, when you're ready, let us know. Okay, we're back on the record. Mr. Romero, who are we asking to call first? Someone out of turn?
Yes, Judge, thank you very much. And Mr. Sapio, he is on page 21 of your docket.
All right, Mr. Sapio, you're before the court for possession of methamphetamine. Count 2 is petty theft. Count 3 is possession of cannabis 20 grams or less. Count 4 is possession of cocaine. Count 5 is possession of drug paraphernalia.
Do you have anything on him? My system's acting up now. Yours is doing the same thing mine is.
Yeah, the court does find probable cause.
Judge, it's being Mr. Sapio, unfortunately, he's financially indigent and nobody's going to be able to post his monetary bond. He's 57 years old. He's been here his whole life. He's currently, from what he advised me, he's looking for work and he's homeless. He does have a mailing address. It's a friend of his who resides in Hallandale, where he can record correspondence to make sure he comes to court. So, Judge, considering these are nonviolent offenses, we're asking the court to consider releasing Mr. Sapio on pretrial release.
State would oppose. Mr. Sapio has 19 prior felony convictions. His last prior was in Dade County last year. And that was for felony theft and nothing further from the state.
It,
Did we hear him?
there are, finding probable cause, I'm going to leave the bonds in place, Mr. Sapio, and, there are several drug charges. If there's a place, that, Mr. Sapio, can go to, I'll sign an order for,
Is there anything else?
transfer to whatever
There's no rest of
facility, if
reason.
there's one that's found. Giovanni Cabreja,
Mr. Cabrera is here. He's approaching, Judge.
Mr. Cabrera is before the court. Count 1 is possession of heroin. Count 2 is delivering or distributing MDMA. Count 3 is trafficking in oxycodones. 4 is possession of cocaine, and 5 is resisting without violence. The court does find probable cause.
Judge, I'm going to be asking for the court to consider a bond reduction, specifically on count 3. As you can see, the bond is currently set at $75,000, and from what Mr. Cabrera had advised me, financially, he's not going to be able to afford to post a monetary bond that high. My understanding is he's been living in our community his whole entire life. He is working right now. He works for a company called Centurion Cleaning, where he's been employed there since 2015. He's on salary. He gets approximately $1,500 per month. Right now, he's living with his family in Miramar. The person he's going to be contacting to help post his monetary bond is his girlfriend. And from what he informs me, his girlfriend is on disability, and there's no way she's going to be able to afford the $75,000. We're going to be consider reducing that bond from $75,000 to $10,000, and that is what the defense is requesting for at this time, Judge.
Your Honor, state would be requesting the bonds be kept in place plus a GPS monitor. Even with no history, Mr. Cabreja would be facing a 3-year minimum mandatory prison sentence. I would note in this instance, according to the report, he admitted possession and ownership of the drugs. He has a history of drug dealing. 2008, he was convicted of federal charges of possession of cocaine with intent, selling marijuana. He was sentenced to 105 months with the Federal Bureau of Prisons, 5 years supervised release. He violated his supervised release and was sentenced to more prison time in 2017. Prior to that, in Dade County, 2007, he was convicted of trafficking MDMA, sentenced to 2 years in state prison, and his sentence date ended in 2010.
Okay, then the standard bonds, counts 1 through, all the counts will remain in place. Kirk Robertson,
Mr. Robertson, come on up, please. He's approaching, Judge.
Mr. Robertson, you are before the court on 3 counts of aggravated assault with a deadly weapon without intent to kill. The court does find probable cause. I'll hear from the parties as to bond.
Good morning, Judge. I'm the defendant's sister. I'm just here to say that he's a well-rounded kid. He's been helping me out at home. So I just wanted to stop by and just speak on his behalf. And today's my mother's birthday, so I'd like to bring him in as a gift if possible. So thank you.
Okay.
Good morning, I'm Mai Tran. I just want to say that he's really hardworking, he's really responsible. I've pretty much grown up with him. He's helped me out a lot, and I just really like for him to come back to us.
Okay.
Your Honor, I don't see a criminal history. That being said, the allegations in this case are alarming. We have 3 witnesses, employees at a Wendy's, stating because he was not allowed to enter a Wendy's with a live snake, he came back with a gun and threatened the lives of 3 individuals. I'm requesting bond in the amount of $10,000 on each count, pretrial release with a GPS monitor, no victim contact, no return to this Wendy's.
Judge, in speaking with Mr. Robertson, as you heard from the state, it is correct. He has no prior contact with the criminal justice system. It's the first time he's been arrested in his life. He is a registered voter here in Broward County. He has strong ties to this community. He's a graduate of Monarch High School, class of 2016. He did advise me that he wanted to be a firefighter. He went to the academy, but unfortunately, because of family obligations, he left that and now is working at a landscaping company. He's been there for about 5 years, making approximately $750, I believe, bi-weekly. Now, lives in Pompano Beach. He lives with his sister, and he's grateful that his sister is here for support. My understanding is, Judge, that she's unemployed. They're going to be reaching out to friends and family to help post his monetary bond, but financial resources are quite limited. I understand the serious nature of the allegations. We're going to be requesting a $2,000 bond on each count. That would be a $6,000 bond, and we wouldn't have an objection as far as having Mr. Robertson also supervise on standard pretrial release. So that is what we are asking for at this time, Judge.
All right. The court does find probable cause. The allegations are concerning. There is concern for the community. And based on that, I believe that a reasonable release condition this time, $5,000 on each count, and that's going to be with a level 2 GPS.
Your Honor, and as far as the no contact, no
And
return.
no victim contact and no return. So what is this business, Wendy's?
It's a Wendy's on Martin Luther King Jr. Boulevard in Pompano. And I apologize, Your Honor, I should have asked earlier. I'd also be asking that a condition be that Mr. Robertson not be in possession of any firearms or weapons.
Right, no weapons or firearms. All right, good luck, sir. Cassidy Williams.
He's approaching, Judge. You have me.
All right, Mr. Williams, they're before the court for 1 count of possession of alprazolam, count 2 is possession of drug paraphernalia, and count 3 is trespassing. Court does find probable cause.
Judge, in speaking to Mr. Williams, fortunately, he's going through a difficult time financially. He's homeless. He's been here his whole life, but from what he advised me, this is his first arrest. So if the state can confirm it, and this is a nonviolent charge, I'm asking for the court to consider releasing Mr. Williams straight ROR. If the state cannot confirm it, then I'm going to be requesting for Mr. Williams to be released on supervision with pre-trial release.
I see no history, Judge.
Okay. All right, Mr. Williams will be released on his own recognizance.
Thank you, Judge.
Cardi Lounge, Achille.
He's approaching, Judge.
All right, sir, you're before the court. Count 1 is carrying a concealed firearm. Count 2 is possession of cannabis, 20 grams or less. And count 3, which is not for magistrate, is a traffic infraction. The court does find probable cause.
Judge,
Achille, correct. It's Achille.
I'm speaking to Mr. Achilles, he's 21, been here his whole entire life. Most importantly, he's saying this is his first contact with the criminal justice system ever. So if the state can confirm it, we're asking for a straight ROR. If not, he did give me the phone number of several individuals that would be able to post his monetary bond. So Judge, we're reporting ROR if he has no prior contact.
I see no history, Judge.
All right, Mr. Achille, your ROR will be granted. Alex,
Getting a court date in about 3
Alex
weeks.
Chile.
Come on up, sir.
Oh, wait, so I'll be.
Yeah. Who's here?
Sir, you're before the court. Count 1 is resisting officer without violence. Count 2 is distributing or delivering cocaine. The court does find probable cause.
Judge, it's being Mr. Chile. He believes his bond may already be posted. If we could check with confinement status to see if his bond's posted.
It's not showing, is it?
It will be shortly. Thank you, Judge.
All right. Well, the standard bonds are in place. Devon Thomas.
I've been advised he's bonded, Judge.
Okay.
Mr. Williams?
Milton Williams.
He's here, President Mingus.
In reference to the charge and the statute that was used, it's an aggravated battery.
All right, Mr. Williams, you're before the court for 1 count of aggravated battery. The court does find probable cause. All right, I'll hear Esteban.
One moment, Judge. Your Honor, I'm going to be requesting a $20,000 bond, pretrial release of the GPS monitor, no victim contact. This is based on the level of violence where he allegedly punched and attacked the victim, who is they have children in common with, causing her to fall to the concrete, hit her head on the concrete. While she's laying on a prone position, he straddles her, continues to punch her in the face with closed fist. This caused the victim to sustain a contusion above her left eye. Her left eye was swollen shut and a fractured nose. I would also note that according to reading the report, it appears this was done in the presence of their children. Mr. Williams was arrested in 2016 for a felony battery due to priors. That was dropped. 2013, he was convicted of DUI property damage with enhanced breath. He had a battery in 08, another battery in 08, disorderly conduct 08, unlawful use of false name 08. 07, he was arrested for battery and child neglect, and those charges were dropped. Nothing further, Judge.
Okay,
Judge, in speaking to Mr. Williams, he's looking very much forward to fighting these and disputing these allegations. I told him that's going to be for a separate day, unfortunately. At this time, the court is bound by the PC affidavit. Having said that, Judge, he's 33 years old, been here his whole entire life. He is working. He works for a company called K&E Mechanical, where he's been employed there now 2 months, making approximately $13 an hour. Judge, from what he advised me, he's not going to be able to afford to post a monetary bond that the state has suggested. We're going to be asking for a $5,000 bond on his behalf. And also, we're going to be asking for a photo order so we can photograph the injuries that Mr. Williams sustained.
okay, I will sign that photo order. Finding probable cause, I am going to impose a bond of $20,000 with a level 2 GPS. No victim contact. Sir, no victim contact means no phone calls, no text messages, no writing, no asking another person to speak to the alleged victim on your behalf. It means what it says, no contact. Do you understand that, sir?
Yes, ma'am.
All right, good luck,
Just for
sir.
point of clarification, I know the alleged victim, I believe Mr. Lender said they share children in common. My understanding is that the alleged victim is his sister-in-law. Does it have the name of the victim?
Okay. I might have misunderstood. I
Alicia
understand,
Harden?
yes. It's Alicia Harden, so I mean, they don't have children in common, Your Honor, but
He knows not to have any contact with her.
All right. Okay, Cody Cody Syker,
Medical reset, Judge?
okay? And John Tyre,
Medical reset, Judge?
okay?
Your Honor, I just ask if the court, if the court can make a PC determination on those two cases, please?
On Mr. Tyre, was the last person, there is a, count 2 is a no bond hold for a felony capious matter. Mr. Faberich, do you know if the PDs represent Mr. Tyre? He has one, and then so that's the reason why I say that on Mr. Tyre. Based on my notes, he has a status hearing in his division tomorrow. Mr. Syker, I don't know, I'll make a probable cause finding, and he has to come back for bond status.
Yeah, and because the other individual has that capias,
Which one?
every day we reset him in
Piker.
here, he's gonna continue having a status set for the following day in his division.
Okay. All right, so we'll make a probable cause finding as to tire as well. And, no, that's okay. That's all right. All right, I think we're at the end of our docket then.